guys, it's Kathy. I hope you're doing well. Raven's here. CJ, that sounds amazing. That sounds so beautiful. Uh oh. Okay, good. How are ya? All right. We're going to start with OJ. This is the trial. We're, oops. We finally made it to the trial after after the preliminary hearings. I suspect, I'm not sure, but I suspect that as detailed as they were in the preliminary hearings, they're going to go way, way, way more detailed here. So it's going to be, fun to sit and listen to it over and over and over again. But I'm sure it'll be fine. I'm sure it'll be good. A new, what is that? A new view of the courtroom. I wish they, it just looks like, I don't even know. What is that? Look at all this stuff they have in the courtroom. Look at their projector. Hi, person. Hi, Ginny. Let's start this trial. There he is. Oh, it's a new judge. It's a new courtroom. It's a different courtroom. Or is it the same courtroom? It looks the same with the plexiglass there. Could be the same courtroom, just new judge.
All right, good morning, counsel. All right,
The camera angle's way worse. We can't see anybody.
back on the record in the Simpson matter. Mr. Simpson is again present before the court with his counsel, Mr. Ullman, Mr. Shapiro, Mr. Cochran, Mr. Douglas, Mr. Bailey, people represented by Ms. Clark, Mr. Darden, and Mr. Hodgman. All right, counsel, we have just a few matters to dispose of before we reach our opening statement stage. Counsel, yesterday the jurors, when they retired, one of the jurors handed the bailiffs a note for the court, and they were just curious as to whether or not the court was going to allow them to watch the Super Bowl this weekend, and I've indicated to them that yes, they can, and that we would arrange their visitation schedule accordingly. So I take it there's no comment on that. All right, Mrs. Robertson, would you create a file for juror notes, please? All right, first issue to be resolved is the defense motion to allow Mr. Simpson to briefly address the jury during the course of defense counsel's opening statements. All right. Certainly.
I did. It was very nice. I loved it. And your daughter.
Your Honor, the first objection interposed by the people is that this has never been done before. And we have located at least two California precedents where it has been done before.
They gave them a microphone at their table. Oh, that's awesome. That's good.
The first came in probably the first case of the century, which was the trial of Clarence Darrow here in Los Angeles for jury bribery. Even though Mr. Darrow was represented by eminent counsel Earl Rogers, he was allowed to directly participate in the presentation of the opening statement and closing argument to the jury. The second example came in 1972 in the trial of Angela Davis in Northern California, in which, although she was represented by counsel, she also was allowed to present opening remarks to the jury. So it's not a question of proposing something that has never been done before, as to which there is no precedent. The second objection raised by the people is that they will be deprived of their right of cross-examination. And I think that really misconceives what is being proposed here. First of all, Mr. Simpson will not be testifying, and the standard instruction given to the jury with respect to all of counsel's opening statements, that they are not evidence and not to be considered as evidence by the jury, will certainly apply as well to Mr. Simpson's opening remarks. But what is being proposed really is not a presentation in the traditional form of an opening statement. What we are simply proposing is that Mr. Simpson be allowed to introduce himself to the jurors, to introduce the defense team, the lawyer.
He wants to talk to the jury first before the trial starts? Or opening statements when the trial starts? What? What? No. No, he doesn't. This is a joke.
Lawyers who are representing him,
Oh my gosh.
and to simply reiterate his plea of not guilty. Now, of course, the prosecution has no opportunity to cross-examine a plea, and we believe it would be quite appropriate for the jury to hear the plea of not guilty that sets this trial in motion directly from the lips of the defendant.
Nope. I disagree. If he wants to talk, he needs to get on the stand. You can't just talk in court whatever you want to, however you want to. Yeah. You think it's an intimidation, or that he's trying to bedazzle them with his stardom?
This is not really all that remarkable a request. What it really seeks to do is to focus the attention of the jury back where it belongs in the midst of all of this hoopla, and that is on the defendant who is on trial, to remind them that what's really at stake in this trial is one man's freedom. We want them to see who that man is. We want them to hear from him very briefly in terms of
Happy New Year.
Of introducing himself, introducing counsel, and reiterating his plea. The second part of the motion simply addresses a physical demonstration that is routinely done in trials, routinely done by the prosecution as well as the defense, and again would not involve any testimony but simply a preview of evidence that will be presented in the course of the trial.
All right, Mr. Ullman, it was represented to me that preview would be merely of the defendant's knees regarding certain surgeries that he has undergone as a result of his athletic career. Is that correct?
Yes, that is correct.
All right. And have you contemplated the security desires of the Sheriff's Department that they have their bailiff within close proximity of Mr. Simpson at the time that this is done, and how you would do that in a manner that would not convey a unnecessarily negative message to the jury?
Well, that was the reason we brought this up in advance, Your Honor, so that adequate preparation could be made to post a deputy on this side of the courtroom if that's necessary. But it simply involves him walking from one side of the courtroom to the other.
All right, and unfortunately, the logical place to do that is right by prosecution counsel there. So we have that proximity problem as well. Have you contemplated the logistics of our unfortunately small courtroom?
Well, if the prosecution wants to just switch sides with us, we'll be glad to move over to this side of the courtroom. But
you've asked for that already.
I don't think that they have any concerns about being in proximity of the defendant.
Well, I just have concerns about that as a security concern is all. All right. Thank you, counsel.
Could we have just a moment?
I don't understand the problem. I don't understand what the surgery on his knees has to do with him walking across the courtroom. I don't understand. Do they want to show him walking to show that he's
Mr. Cochran
disabled
has
or
discussed
something?
the issue with the bailiff, and there's no problem with the bailiff being in proximity while Mr. Simpson addresses a jury or displays his knee.
All right. I'll hear from the people.
Thank you, and good morning, Your Honor.
Morning.
First of all, this is not an opening that counsel proposes. It's simply an attempt to capitalize on whatever defendant's star appeal currently is with the jury and to get him to have close proximity with them to impress them. What is the probative value of a scar? What does it prove to this jury in terms of his physical capabilities on the night of June the 12th, 1994? It proves nothing. In fact, we all know that on the morning of June the 12th, he was playing golf. We also know that within weeks before the murder, he made an exercise video. So the probative value of that scar is nil, and the misleading nature of presenting that scar to the jury is great. The inference that the defense will seek to draw from that scar is that he was incapable of certain physical acts. If that is what they intend to present, that's fine. Let them present testimony that is capable of cross-examination. But to have the defendant essentially testify before the jury without taking the witness stand and being cross-examined is inappropriate. The cases in which the defendants have been able to address the jury in opening statement in previous occasions have been cases where the defendant was acting in pro per. This defendant is not in pro per. He is represented by many attorneys. If he desires to testify before this jury, then let him do so as all witnesses do, on the witness stand and be subject to full and complete cross-examination. Case law is completely in favor of the people's position in this regard. People v. Perez, 216 Calap 3rd, 1346, in which the defendant requested to be allowed to exhibit his tattoos without being sworn or giving testimony. The court refused his request and ruled that the exhibition of the tattoo would be testimonial if offered, to impeach the testimony of an undercover officer, and essentially that's what the injuries now being proposed to be displayed to the jury is being offered to show, that he could not, in fact, commit certain acts that he is charged with committing. It's testimonial in nature. Let's make no mistake about that. What is the purpose otherwise of demonstrating the scar or of talking about or showing the jury what he can and cannot do? It's going to give him the ability to limp up to the jury box, get close to the jury, and try and impress them with his physical presence. That there's nothing appropriate and there's no legal benefit to this in terms of what is appropriate in a court of law. If the defendant would like to testify, that's fine. But to do this and then shield himself from cross-examination, say, don't ask me any questions. I just want to get up there and show you something. I want you to draw inferences from this. I want you to take evidence from this without being subject to cross-examination is entirely inappropriate. The people would not be entitled to do that because there would have to be a foundation laid. People v. Perez makes that very clear. It indicated that it would be irrelevant as demonstrative evidence as well, which is what the defense claims it's proposing here. Although the people dispute that, and really it's a testimonial in nature kind of thing they're proposing. Nevertheless, even if it's demonstrative, the court in Perez ruled that because the defendant had laid no foundation for the admission of the evidence, it was appropriately denied. In this case as well,
so you know how I said was not going to, we were only going to show one video, it wasn't going to be a 2-hour stream? This is a 2-hour video. So I am going to stop it somewhere around here, right when he's done talking. And then we'll finish the rest of this video tomorrow.
The defendant proposes to do requires either his presence on the witness stand or some testimony from the witness stand to lay a foundation for its admission. To simply display something to the jury without any evidentiary basis gives them nothing reliable and nothing of probative value. It is only a blatant attempt to impress the jury with his charisma and star appeal. That is not an appropriate vehicle in the opening statement.
It is not
appropriate. Let me indicate also that the case of People v. Wong held similarly. People v. Wong, the trial court indicated that it was improper to have the defendant exhibit his arms to the jury without first being sworn as a witness. In that case, 35 Calap 3rd, 812. The defendant in that case wanted to indicate that he was not an addict, he had no track marks on his arms. The trial court refused to allow him to do so unless he subjected himself to cross-examination. On appeal, the court was upheld, and it was determined that if it was a testimonial, if it was being offered as testimonial evidence, it was properly refused when the defendant declined to be sworn as a witness and subject himself to cross-examination. It also ruled that if the offer was a demonstrative one, then the trial court was justified in rejecting it on the basis that it was irrelevant. As I've indicated to the court yesterday, his arm was being offered on May 12th, 1971, to show the condition of his arm on June 5th, 1970. The defendant's condition today,
Thank you,
or the
Fozzie.
existence of that scar, without laying a foundation as to what the significance of that scar is and how it impacted on his physical capabilities, is something that exists without foundation. It has no probative value in and of itself. If the defense wants to do it as part of an opening statement, they're going to have to also proffer something that lends it some value in terms of probative value. What I mean by that is they can offer a photograph of the defendant's knee, but simply holding a photograph up isn't going to get them very much, shouldn't. But the defendant, in terms of its evidentiary weight, because what does that mean in terms of his physical capabilities, or his limitations? Having the defendant as well get up to tell the jury that he's not guilty is another attempt, blatant attempt, to have the defendant address the jury without being cross-examined. It's like issuing a blanket denial and then saying, you can't ask me any questions. In a court of law, Your Honor, when a defendant seeks to testify and issues a blanket denial, that opens the doors to cross-examination as wide as they can go, and the people are permitted very far and wide-ranging cross-examination. The defendant seeks to do that in this case and preclude all cross-examination. He seeks to protest his innocence and yet not allow anyone to ask him any questions. That is entirely inappropriate. The court, I'm sure, is very well aware of that. If he were in pro per, he could get up and say whatever he wanted to. He's not.
All right, what's your page cite on People versus Wong?
835.
Hi, Gina.
What's your page cite on Perez?
And on 1348 and goes on to 1349. The holding, 1348 and 9 give the factual exposition, 1350 gives the ruling.
Good morning. Hi, John Love. I have no idea. Maybe I'll see what I can find real quick.
All right, any other comment?
No.
Thank you. Mr. Ullman?
The suggestion that a plea of not guilty subjects a defendant to cross-examination is simply not the law. The plea of not guilty is what sets this trial in motion and puts the burden on the people of proving guilt beyond a reasonable doubt. It's really incredible to suggest that somehow the jurors will be prejudiced by actually hearing the plea of not guilty from the mouth of the defendant himself. Actually, the only person who can enter the plea is the defendant himself, and that plea is what sets these proceedings in motion. And we believe it is quite appropriate and does not open up any doors to cross-examination, simply to have the jury observe the defendant and hear his plea of not guilty from his own lips. The suggestion that this is some sort of ploy to capitalize on the defendant's charisma or celebrity status, it's just the opposite. It is just the opposite. We do not want this jury to view the defendant in terms of a celebrity. We want them to view him as a human being. And that suggests the greater need in this case to do it, because there is just so much starstruck quality about this whole proceeding, and we think it would be very healthy to remind everyone, especially the jury, that what's at stake here is simply the liberty of a man, a human being, and here he is.
And you can do that in your opening statement, and you can do that through testimony. But what you're trying to do, sir, no, inappropriate.
O.J. Simpson. In terms of the lack of foundation for the physical capability of the defendant, that will be presented in the course of testimony. Obviously, the opening statement doesn't present all of the evidence. It's a preview of what is to come, and this is an important part of the evidence that we would like to preview for the jury. When it is presented in the course of trial, there will be foundational testimony from Mr. Simpson's physician as to his physical capability to corroborate the physical demonstration.
Well, when you say demonstration, now you got me scared.
Yep, he just said it's going to be testimony. He just said it.
Is this an exhibition? Exhibition or a demonstration?
Exhibition.
Two different things.
Right.
Okay. Thank you, counsel.
Thank you.
All right, I've reviewed the cases cited by the people, and the only cases that I could find that were of interest were a case out of New York and a case out of the Supreme Court of Mississippi that dealt specifically with the request of a represented client to address directly a jury. The motion to allow the defendant to directly address the jury will be denied. The motion to allow him to exhibit to the jury his knee injuries or the result of the scarring and the surgeries will be allowed. All right, counsel, we need to resolve then the last remaining issues on the exhibits, and we'll be prepared to go forward with opening statements. Mr. Douglas.
Thank you, Your Honor. Good morning. Yesterday evening, Your Honor, we were attempting... One moment, Your Honor. Yesterday evening, Your Honor, we were discussing the possibility of making alterations to the SOC timeline chart, of which there was an objection. As the court will see, we have altered the offending language to reflect the details and circumstances of a report that was part of an analyzed evidence report that I'd like to submit to the court and which I have already given to opposing counsel. What it says basically, Your Honor, is that there is a notation referring to different pieces of evidence. There is a notation for socks, navy blue / black. There is
the June 29th report.
This is a report, Your Honor, if I may approach.
No, just answer my question. Is it the June 29th report?
Yes, it is. And it talks about there being, quote, dress socks, semicolon, blood search, paren, none obvious, close paren. And we would submit, Your Honor, that this is in fact a fair reflection of what we think the evidence is going to show. We would submit that that chart is not unduly prejudicial, and we would submit that the court should overrule the objections and allow the admittance of that chart.
Who was the author of that report?
LAPD has a hard job. I mean,
This refers, Your Honor, this document apparently was prepared for the split hearing. It's Peoples 2 at the split hearing. And Yamauchi, Kessler, and Matheson each testified about the process by which they took out different pieces of evidence and examined it. And this was a document that was prepared specifically for that hearing.
All right, that doesn't answer my question.
Who prepared the report?
Who prepared that report?
Michelle Kessler, Greg Matheson, and Colin Yamauchi.
Was that the index that was prepared, the evidence index?
It says summary of analyzed evidence by analysis performed. That's the title.
Okay.
It's Exhibit 2 at the split hearing. The remaining objection, Your Honor, would be in response to the concerns about the videotapes and the scenes that were reflected of different officers walking through the crime scene at various times. We have now obtained the remaining tape recordings, and Your Honor, there was a misstatement yesterday. The scenes that were shown in the tape that has been given over to the people are not scenes that were taken from CNN, but rather they are a collection of different tapes that were received from different local news media, so that for us to introduce these different snippets, if you will, at trial, we will simply be able to lay the foundation by subpoenaing and bringing in to testify those operators of, I think it's local channels 5, 7, 11, and 13, from whom these particular snippets were culled. That tape has now been provided to the court, and that tape has also been provided to the people. We now have the tape from San Francisco that had 2 other blips that were not shown on the first tape. I am told by Mr. Hodgman that the people would continue to maintain their objection. So what I propose, Your Honor, is that the court allow the showing of the scenes that were displayed yesterday. They are scenes, Your Honor, that are very capable of being authenticated. In many ways, it is self-authenticating. In many ways, they are authenticated because there will be an evidence or a police log where each individual who comes onto the scene first checks in with one of the police officers that are there. That log will be an item.
Your Honor, I don't need to lay any foundation for this piece of evidence because it's authoring. It's just going to do it itself. I don't have to do anything. It's fine, Your Honor. It's fine.
Item of evidence, and it is possible by showing the scenes and having those depicted there testify to establish clearly when the various pieces of scenes were taken and what sorts of things were occurring. It is true, Your Honor, that it is the people's crime scene. It is true, Your Honor, that they themselves do not have a videotape of the crime scene. There are certain discrete acts that are going on. For example, Detective Lang measuring a certain location. For example, you see criminalist Fung placing down particular evidence tags. You'll see detectives walking through, Detective Van Adder and Rogers walking through, and quite clearly the sheet is there because the body has been removed, but the sheet remains, and it shows, Your Honor, the sort of sense that we are going to depict in words. It helps to provide a visual context to the words that Mr. Cochran is going to speak. He is going to discuss how the evidence will show that there was contamination of the crime scene, we would then hope to show pictures that demonstrate, that reflect the contamination of the crime scene. They are going to
Yes, sir. This is the full trial. We just started it.
offer evidence, I suppose, Your Honor, how the crime scene was not contaminated. Perhaps they'll show that when these scenes were shown, all of the items of evidence had been collected. Perhaps they'll show or they'll offer evidence that when these scenes were shown, it was the next day or the third day after. That is the risk that we are going to take by the statements that we are going to make in our opening statement. But whether or not there are the visual reflections of certain words, Mr. Cochran, I think quite properly, will be able to discuss and to speak about how the crime scene was contaminated and how we contend these scenes are simply a small reflection from the only live record that is available showing the conduct of Detectives Van Adder and other detectives at both the Rockingham and Bundy crime scenes on June the 13th. Your Honor, that I think is the end of my objections to the charts that the people are going to offer and my explanation to the items that were remaining yesterday.
Thank you, Mr. Douglas. Ms. Clark? I'm sorry, excuse me, hold on a second. All right, Ms. Clark?
I thought that the court had concluded its ruling yesterday with respect to the tape. Mr. Cochran made a motion that when a ruling is issued, we not re-argue it, and we all agreed to that.
Well, what I said yesterday is that if the defense makes the videotape available to you, and after reviewing the tape, you still maintain, I mean, who knows, after looking at it, you might have changed your mind. Now that you've had the opportunity that's been brought here, what's your position?
We haven't had a chance to see it. They just gave it to us this morning when we walked into court.
How long are these videotapes, Mr. Douglas?
Your Honor, the first tape was played, I think, in its entirety yesterday. This
Are the tapes rewound, though? Because if she has to take the time to rewind them first before she can watch it, she's going to need more time.
second tape, which is we got this morning from San Francisco, it's approximately 25 to 30 minutes long. However, a lot of that is a press conference by police officers. The first 5 or 10 minutes contains the 3 clips that we wish to use in opening today.
The first five or 10 minutes of
Yes.
this?
In addition to the ones that we showed yesterday.
The same problem exists now as it did before. We don't have a foundation as to time, and time is very important. The bloodstains were collected at a certain point, and that's not established with the tape. Secondly, there's a counter at the bottom of that tape that's very misleading because it looks like all of these different, actually, pieces of tape were one continuous shoot, which is not the case, as counsel even concedes. There was considerable editing done to that tape, and the people maintain their objection.
All right, don't you think we ought to at least look at the first 5 or 10 minutes to see if you still do?
I will, certainly, Your Honor.
All right.
I'll be glad
Those
to.
are
Let me
delicious,
go on
Raymond.
to the other exhibit. With respect to the SOC timeline,
Yes.
what Mr. Douglas has represented to this court is very misleading. And I confronted him this morning, and I explained to him that on this is not a business record, I should indicate to the court, first of all. It was a chart prepared specifically for the Griffin hearing and the blood split hearing, actually, at my request, because I wanted to see exactly what they planned to do with all the items of evidence and what seemed to be sufficient for a split, what did not, what was capable of PCR, what seemed to be capable of RFLP. In the box marked comments, it shows blood search, because that is what they planned to do. It had not yet been done. These are navy blue to black socks, which, if you look at it with the naked eye, you're not going to be able to see anything. It was scheduled for a blood search, and it was put down that none was obvious because on a black pair of socks, you're not going to see blood. It's going to be, at best, you might see something wet, but after a period of time and it dries, you won't even see that. So it was scheduled for a blood search, and what Mr. Douglas has on this chart is very misleading because it indicates that they have already looked for blood and that none is obvious. This is exactly the problem. Is that the jury is, and if Mr. Douglas had spoken to Mr. Matheson, he would tell him. We put it there, as many of the other items listed in this comments column, as a prospective plan. You can see on this list, it says, just above it, the item number 12, swatch, RFLP possible, and on previous items, it shows RFLP would consume, PCR only. It's very obvious what this is. They're talking about what is capable of being done or what they plan to do. Not that it's been done, it hadn't been. So what counsel has put there is, again, completely misleading. It's the opposite of what occurred.
All right, let's take a look at the videotape and see what's there.
May I also request leave of the court? There was one chart we had not yet seen that we only saw a Xerox copy of. I wanted to address the court further on it, and I think I can do that better if I have the chart in front of the court. That was the chart entitled Deceptions, Distortions.
I thought you said you had no objection to that.
I had lost my copy of it at the time, Your Honor. There is language on it that I wanted to object to, not the entire chart, but certain language on it, and I need to confirm that that is on it. If it's not, there will be none. But that is the problem with not having everything in court on Friday as the court
Counsel, is there a
requested.
reason you didn't tell me that you didn't have it in front of you when you asked me to rule on that?
I apologize to the court. I thought that...
I mean, I can't keep doing these things over and over and over again.
I'm only asking leave to see the chart as it currently exists. I have not seen the final hard copy. All we saw was a rendering on an 8 by 10 piece of paper. I would like to see what the final chart says.
Mr. Douglas, do we have that available?
We're looking around.
I have it, Your Honor. The chart is being mounted right now and will be picked up this morning. But it just mirrors this particular chart.
Does the court have a copy of this?
No.
Do you have an extra copy?
No, that's the only one.
All right, would you hand that to Mrs. Robertson, please?
I want to address the court on certain aspects of this chart.
You know, we could put it up on the envelope.
Well, that'd be great.
I let that go. I don't know why they're allowing them to present evidence on day one of trial. That can't be allowed. I don't know why this is happening. This should all be done with by now.
Hold on, I can't see the entire chart.
You can't either, okay.
No.
That's good.
All right. Wait, focus that a little.
With respect to the first entry, Mark Furman and the gloves, it indicates plural. At no time did Mark Furman so testify, and the chart is misleading with respect to that language. The people object to the use of the plural. That never occurred. Secondly, Van Adder warrant. The search warrant and the circumstances of the search are irrelevant to the trial before the trier of fact. That is a legal issue that the court rules upon that is improper to raise in opening statement, let alone in trial. I would further mention to the court, I thought the court ruled that Mark Furman could not be mentioned in opening statement.
That's correct.
And the people object on that basis as well.
John, my good question, Your Honor.
Furthermore, the Ron Phillips statement to the coroner. We're kind of not following procedure, but we're kind of asking a favor. A statement lifted out of context that is hearsay from a transcript that was issued by the coroner, not a statement made, not a report made by Ron Phillips, and is misleading and confusing on that basis.
All right.
Okay, I know that everybody says that she did a bad job. I don't think so. Be, for a couple reasons. First off, I just don't think so. I think she's doing a fine job. Second, the whole world believes he's guilty. So did she really do that bad of a job?
All right, Mrs. Clark, before you get too much further, counsel, this is an argument. This is not an opening statement exhibit.
Good morning, Your Honor.
Good morning, counsel.
Your Honor, in this matter, it was my understanding yesterday that the people had an opportunity to look at everything. We did show this to them. And Ms. Clark indicated she had no objection. We don't want to be argumentative. This was passed, we thought, out of an abundance of precaution, if the court pleases, because we anticipated that she might change her mind. We have another chart, which I think the court will find hopefully less argumentative. I'd like for the court to take a look at it. I think this is what this is basically is a summary of the conduct. And I wanted one other query of the court with regard to Mr. Furman. The court did not say we could not talk about Mark Furman. I understand in opening statement what you indicated was that with regard to the Kathleen Bell incident, I think you said, but you never said we couldn't talk about Mark Furman. Is that my understanding?
That's correct.
Okay, I want to make sure that was clear. May I show this to Mr. Hodgman and then give Your Honor a copy of this, what we proposed? Thank you.
Is this a change to this document?
Yeah, it's a change to this document. You want to put it up there? Can we put it up for you? Let's put
Please.
it up. You got one? Okay, what's up now?
She mad? You mad, bro? He did. On the day of trial, they're worried about all their video, all their documents. This is crazy.
With regard to these items, the court will recall that as part of the exhibits, we will have a video clip of Detective Furman. If Ms. Clark objects to the use of the words gloves, I will stipulate to strike and make it glove, but we still are going to play that clip. With regard to Detective Phillips, we actually have a transcript. We passed this yesterday. That's already coming in. We don't want to take any out of context. People will be able to see exactly the transcript, so nothing's taken out of context. With regards to Detective Van Adder, where the statement is made that Simpson had left on an unexpected flight to Chicago. What we're talking about is not relitigating the issue, the court pleases, of the entry, but to indicate that in the very first contact with the criminal justice system at 10:45 on 6/12, an untruth was told. That in that warrant, under oath, they did not tell the truth. And we have that, and you saw yesterday Cato Kalin's statement. Your Honor, with regard to securing, documenting, and preserving the crime scene, everybody has been very much aware of that the trainee, Mazzola, was her third crime scene, was basically the officer in charge there. With regard to the Bronco, we've litigated this. Counsel is known for some time. We've made it in as innocuous language as we can, that they failed to give that special care for evidence presentation. We showed all this yesterday, Your Honor. They went through it. They had no objection. The DNA testing, we've said consistently. They can talk all they want about DNA. But all the DNA evidence passed through the LAPD before it went to any other lab. And we think it's our right to talk about that. We have a chart that we've already passed on of the O.J.'s blood vial, and this mysterious blood vial and its saga, where it went, instead of being booked appropriately. And then finally, the question of the socks, whether or not there was none obvious in the socks. I disagree with my learned adversary that blood is red, albeit dark red. It's not black, like socks. and you would be able, I suggest, to see it. And I think the question is, the prosecution thinks that they have a theory, and if we don't agree with that theory, they think they're always right. That's what a trial is about. That's why we're here, Judge. They're not always right. That's why they lose cases sometimes. And so they're not always right. The jury will make that determination. And this idea of protecting this jury, that's what you're going to do. We're not, you told us yesterday about doing our jobs. And that's when the system works best, Your Honor, as you well know. You do your job, we do our job, they do their job. We don't need Ms. Clark to do the job for the jury. They'll do their job, and you'll do your job. And I promise we'll do our job, Judge. And that's what you ask us to do. That's all we're trying to do here. This is a man that we have contended from the very beginning is wrongfully accused. And they are in for the fight of their lives. And so this is not any game. And so we're very serious about this. We don't want to be argumentative, and we want to just spell out. And we looked at this last night. Even though she passed on this, we think we spelled this out, and I think it addresses all of the concerns, Your Honor. And I think that certainly in opening statement, one can't be precluded about what our theory of the case is in good faith. And so what we're doing now is much more than usual, Judge. They're having a total preview of the things we expect to use.
All right, let's see the videotape as well.
Thank you.
Let me see everything that I have to consider, and then I'll rule. I'd like to see the videotape. Thank you. Does this contain any,
No, Your Honor, this pretty much starts where the other one left off yesterday. The bodies have been removed, but the coroner is still there, and Mr. Fung is putting down his tags.
Mrs. Robertson?
That's a wicked cool tie. Look at that. Ha! Oh, I thought they were circles. They're diamonds. Or squares. Look at all those ladies with hats on in court. How rude. I'm not telling her she has to take her hat off, though. Nope, nope, no way. The judge is not playing Candy Crush. he's still waiting for the video to rewind.
Yeah, I think that contains all the clips that we wish to show in opening. There's a little more after this,
He's
but
waiting for dial-up. AOL is slow today.
All right, Ms. Clark, I'll hear your objections.
How many of these does he need, guys? Look at all those hourglasses.
First of all, with respect to the videotape, Your Honor,
Yes.
again, the same foundational problems we had with respect to time. We don't have the authentication in terms of the timing, and that's critical in terms of the evidence collection. The inference that the defense will seek to draw is that all of the evidence collected by LAPD was contaminated in some manner by the method, by the actions that are shown on the tape. If the evidence was already collected by the time these people are shown in the positions shown in the video, then there is in fact no impact, and the inference that they're seeking to draw is directly misleading to the jury. And that is one thing that in opening statement neither side is permitted to do. The people are not attempting to tell the defense how to try their case. The people are asking this court only to make sure that the jury is not misled, so that they get the truth, so that they understand what the evidence really is, not spin and not distortion and not half-truths or statements taken out of context, but the truth. And the problem with a video such as this one is that we have no way of knowing when it was shot, and the inference that the defense seeks to draw from it may be completely false, in which case the jury begins the case with a total misconception about the conditions under which the evidence was collected. And that is a very damaging thing, and that's why the defense, of course, seeks to do it, I understand. But it's not the appropriate thing to do. The jury deserves to get the truth and understand what the evidence really is.
All right, do you want to address the other issues, the SOC chart and the conduct chart?
Yes, the conduct chart, I think the SOC chart I have, Your Honor, I've addressed that. That is, again, totally misleading with respect to blood search. With respect to the chart, now the new one is even worse than the other. First of all, it repeats the misleading and completely false inference drawn about the blood search. They seek to argue in derogation of reality, in derogation of the truth. The truth is that it was scheduled for a blood search. What they seek to infer from this is that it was already conducted and none was obvious. And that is exactly 180 degrees opposite of the truth. So that is a complete falsehood. With respect to Mark Furman and the gloves, again, it's false. They state, they put on the plural, which was never stated by Mark Furman. They take his statement out of context. There's an extensive colloquy between himself and counsel in which he refers to one glove that he saw at the foot of Ron Goldman, and he says that repeatedly. And yet, taking one statement out of context, they seek to draw inferences from it. It's argumentative. It's not an opening statement, and it's misleading and unfair because it is taken out of context. The same would go for Ron Phillips to the coroner. Of course these are taken out of context. How could counsel argue to the contrary when you have a lengthy transcript of statements that have explanatory information both before and after? You have A and you have C and you take out B. And that's what counsel has done, taken everything out of its proper context and stuck it on a chart. And again, it's argumentative. With respect to the Van Adder warrant, that statement is irrelevant. We're talking about language in a search warrant. That's appropriate for the court to rule on. That's not appropriate for a jury to be presented. The jury has to be the trier of fact to determine whether the defendant is guilty or innocent, not whether the search was proper or improper. That is a legal argument that goes to the court, not to the jury. That statement is inappropriate and it's argumentative as well. With respect to preserving the crime scene evidence, the defense, if they are saying the trainee is Andrea Mazzola was not in charge. She was a trainee who was being supervised by Dennis Fung. So this is false. This is a false statement if that is who they are claiming was in charge of the crime scene. That is untrue and misleading. I thought that the court's ruling pertaining to Mark Furman was that neither side could mention him. That was just Kathleen Bell.
The Kathleen Bell impeachment issue.
Okay. With respect to may I have a moment, Your Honor?
Certainly.
With respect to the items failed to give special care, that's misleading as well. That's put in quotes as though it comes from a manual of some kind, which we know is not true, and it's argumentative. Yes, it's true, all evidence passed through LAPD. No objection to that. With respect to all blood not accounted for, that's argumentative. We haven't seen any evidence of that. If counsel thinks they can lay a foundation through the course of this trial, that's certainly appropriate for argument, but it's not appropriate for opening statement. And again, it's argumentative. I'm just waiting. Is the court?
All right, are you finished with your comments?
Yes, Your Honor.
All right, thank you. Mr. Cochran. Counsel,
Thank you, Your Honor.
I think we need an air traffic controller for the lawyers.
We do, Your Honor. We will be patient, Your Honor, at all times. Your Honor, in this regard, first of all, let me again point out, this is an opening statement, Your Honor, and whereas they have their theories, and we have not said they shouldn't have their theories. We think we have the facts, but certainly contingent upon that, we have certain interpretations of what we think the evidence is. As the court has so correctly stated, we are permitted to talk about those things. If you look at this chart, sometimes people shouldn't object if they have nothing to say. And in this instance, Your Honor, the issue, I already conceded with regard to using the word gloves. I don't want to mislead anybody. We'll take the S off. With regard to Detective Phillips, Your Honor, we have the entire transcript that we're going to have available. The court's rule, we can use that. With regard to Detective Van Adder, we're not relitigating anything. As I said, it's about credibility. And with regard to, and this is where counsel, who supposedly knows her case, should review to her own documents. I'd like the court to see this. Regarding Officer Mazzola, we have a form, 9408-17431, which says OIC name, Officer in Charge name A. Mazzola, Assistant name D. Fung. We don't make these things up. I'll be glad to have them look at that. It's their form. Now, we don't make these things up. And with regard to the field of special care, she says, this in quotes, that's from the LAPD form, Your Honor. Remember yesterday when we showed the form, we pulled that up, where they failed to check the appropriate box when the Bronco was left basically unattended for all those months. Now, she could see the DNA testing did pass through LAPD. Yes, it does, Your Honor. With regard to the blood vial, Your Honor, again, that is our belief based upon all the documents we've been given in discovery. And, if it turns out wrong, that's what we're going to say. This is based upon the documents we've received. It's not argumentative. That's our position, Judge. And she can't tell us what our position is or what it should be. She should understand that right at the beginning. And then with regard to the socks, we'll accept whatever language Your Honor says about that. But again, if you look at this particular form, Your Honor, this form is entitled O.J. Simpson, summary of analyzed evidence by analysis performed. We're using their own forms, Your Honor, by analysis performed. And it says under there that none obvious. And so that's all we've said. We took their own form. And so, there was a recent movie, Your Honor, where there's a line which I think is very appropriate in this case. I think it was A Few Good Men. We keep hearing about the truth. I don't think they can stand the truth. That's what Jack Nicholson said. That you don't want to hear the truth. And that's, I think, it's very appropriate in this situation. That's exactly what's happening here. There's one other thing I'd like to point out.
Wasn't he the bad guy? Wasn't he the bad guy?
Yeah, but bad guys say something worthwhile sometimes, Your Honor. So even bad guys tell the truth on occasion, Your Honor. Certainly we aren't the bad guys in this case, Your Honor. Your Honor, with regard to one other thing you'd asked us to do at the end of the day, and I believe this is on page 25 of Volume 2, Volume 11 of the reporter's transcript of proceedings from Thursday, July 7th, 1994. I'd ask leave of court to read this. It's Mr. Shapiro question. How much blood did you withdraw from Mr. Simpson? Answer, approximately 8 cc's. Question, when you say approximately, you did not measure the amount. Answer, well, it could have been 7.9 or it could have been 8.1. I just looked at the syringe and looked at about 8 cc's. You'd ask us to find that for you, and I'll give this to the clerk. But all we're asking to do, Your Honor, is to stop all of this haggling, and let's start with the opening statements. And we previewed everything, and I think it's time to resolve it.
I believe it's
Right.
your
Well, thank you,
fault
Counsel.
you haven't started with opening statements yet, sir.
All right, the objection to the use of the videotape is sustained. The argument has been that the concession has been that these are snippets and that the defense is willing to take the risk in argument that they cannot lay an accurate foundation. The problem is that leads to the danger of misleading the jury, and I'm not willing to take that risk during the course of an opening statement, so that objection is sustained. As to the SOC chart, the language that is on the SOC chart comes from a summary of reports and testing. It is not the report itself. The objection is sustained as to the language, blood search, none obvious. In all other respects, the SOC timeline chart may be used. As to the conduct chart, the objection is sustained. These quotes, some of these quotes are taken out of context, and there's a danger of misleading the jury as a result, so that objection is sustained. All right, counsel, I think that, I did not rule yesterday on the, Mrs. Robertson reminded me, I did not rule on the photograph of the defendant and 4 ladies in formal dress.
My notes say that the court did rule, Your Honor, that
I noted I didn't check it off on my list, and Mrs. Robertson indicated I didn't rule. So the objection on that, as to that, is overruled. So the record's complete. All right, counsel, that takes care of that. Let me just advise.
Okay. I think this is a good breaking point now that we got the answer to that. So we got an hour of this 2-hour video done today, and we'll do the next hour tomorrow. But we got to see, you can say that you've seen the OJ trial. Everybody's seen the OJ trial. Hi, Jen. But, nope, I gotta stop now. It's already past 8 o'clock. Got work to do. I gotta get a video out or Fozzie's gonna come and get me. Oh, gosh. And I do link the trial in every single video description. So if you want to go peek at what's going to happen next, just go there. But don't. It's more fun to watch it together, but you can. All right, guys. Thank you for coming out. I appreciate it. I'll see you in a couple hours. Victoria, have a great day at work, love. Bye.